Where is your son living now?
He's currently staying with his father, John Elliott.
Why is that?
Because he walked out of my house. He failed 2 classes. He's now in summer school.
From what I was told by Taylor, that he was leaving over there because he was threatened by Kristen's boyfriend, Emmanuel Sukow.
If this court sets this child support at approximately $1,500 per month, would you have to lose time with your children in order to be able to financially afford that?
Objection calls for speculation.
Well, would you have to get a second job?
Objection calls for speculation.
I don't think it's speculation if he knows his finances, Your Honor.
Am I supposed to answer?
Starting with this heated custody battle between Mr. and Miss Elliott. Here's a mother who says her 60-year-old son just walked out because he didn't like the rules, while the father disagrees, claiming their son was being verbally abused, overworked like a slave, and begged to stay away from her home. Crazy, right? Let's see how the judge handles this.
That any testimony you give today will be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, thank you. You can lower your hands. And you may proceed, Ms. Laskowski. Are there any agreements?
No, Judge. Well, I take that back. The only agreement right now is that the child, Taylor Michael Elliott, is currently residing with Mr. Elliott. That's it.
Okay. You may proceed.
All right. The state would first ask the court to take judicial notice of the suit for modification of support order and motion to confirm support arrearage that was filed by the state on February 19th, 2025. The state would ask to take judicial notice of those pleadings and all requests therein and attachments thereto.
I take judicial notice of the pleading I mentioned earlier, as well as its attachments, which include the decree of divorce, which had child support set at $1,300 per month, a release, and I'm not sure I got to the medical support, so you'll have to cover that for me. Because I think as I was reading it, you said you were ready to begin. So someone's providing health insurance. It looks like Mr. Elliott was ordered to maintain it. It was signed by the court. And then there's a very dark page, which I'll admit I can't read. And then I see a pay record attached as well. So I take judicial notice of your pleading.
And the state would first call Ms. Elliott.
Are you able to summarize what everyone's positions are just real briefly? So
Yeah, I can. The
opening statement.
Yes. All right. So Mr. Elliott alleges that the child has resided with Mr. Elliott since September of 2024, while Ms. Elliott alleges that the child has resided with Mr. Elliott since November of 2024. Mr. Elliott is requesting possession credits for that period of time, while Ms. Elliott does not agree to any possession credits for that period of time. Elliott also does not agree to release any arrears or stop child support, while Mr. Elliott is requesting that his current child support obligation be stopped. And
so is this a custody issue?
I do not believe so, but I can take some testimony on that.
I guess why doesn't she agree to possession credits or it's stopping? Does she plan on getting the child back in the near future?
I believe that is the idea.
And so this is a custody issue because he does not believe that. Is that true?
I don't think anyone is asking. There's no pleadings on file, and
well, I realize that, but the crux of this case comes down to who's going to have this child living with them.
Yes.
You can begin. Are you sure none of you want to consult lawyers on this matter? File pleadings that would make this more appropriate? If you can please unmute and answer, I would appreciate it. We are recording this and it can't record head nods.
No.
And Mr. Elliott?
I'm good.
You may proceed.
They would call Ms. Elliott. Ms. Elliott, where is your son living now?
He's currently staying with his father, John Elliott.
Why is that?
Because he walked out of my house.
And can you tell the court a little bit about what happened when Taylor walked out?
Well, he did it 3 times previous to the last time.
How old is this child? What are we talking about?
16.
How old was Taylor when he first walked out of your home?
16.
What month and year was that?
It was the first time or the last time?
The first time.
It was in October of 2024.
And did he come back?
He did.
All right. How long was he gone?
A week.
And where did he go during that week?
He went to stay with John and his friend who they were currently living with.
And
John's friend or your son's friend?
John's friend. He was living with a friend because he travels.
so you mentioned that Taylor has left your home since then. How many times?
A total of 3 times.
And what was the longest time, aside from this last time, then he's been with Mr. Elliott, what was the longest time that your
About
son Taylor was gone?
about a week.
Okay. Are you in agreement for Mr. Elliott to not pay you any child support anymore?
No,
Why not?
because according to the way that he finished out this last year in school, I think it's in his best interest to be here at home with me.
And have you made any efforts to get Taylor to come home with you?
Yes, I did talk to him one time before, I believe it was in January or February, telling him that he needed to come home, that he needed to be here. I felt like it's in his best interest because I'm here, I support him, I get him to school, I get him home, doctor's appointments, dentist appointments at the time that he was in swimming and then he dropped out. And I just feel like it's more stable. It's just him and I.
Okay, I'm just going to
And
remind everyone that nothing is on file for me to address where the child lives. Nothing's on file for me to modify where the child lives. So I'll give you a little leeway, Ms. Laskowski, but just be mindful of that I'm not making a custody decision today.
Ms. Elliott, did you give Taylor permission to stay with Mr. Elliott for any length of time?
no,
All right, why not?
because he walked out.
Okay. And do you know why he walked out?
He walked out because he said that he was frustrated here. He didn't like the rules, the consequences, the responsibilities. And I don't believe that he had the same responsibilities and consequences at his dad's house.
How long has Taylor lived with or been staying with Mr. Elliott?
I would say November.
Has he come since November? Has he come back to your home for any length of time?
Yes,
Okay, when?
he was here for Thanksgiving.
How long?
Thanksgiving, he was here for the day. And then in December, I reached out to him and asked him to come by for Christmas. He never responded. He came and stayed a few weekends between January and March. We've gone to movies, we've gone to dinner.
And are you in agreement for Mr. Elliott to have possession credits towards his arrears for that time since November?
No,
Why not?
because I've been maintaining a household for Taylor to come back to. He's had disciplinary actions in school. He failed 2 classes. He's now in summer school. He's had 10 in-school suspensions since October 28th.
Okay. What were those in-school suspensions for?
Disciplinary actions, insubordination. Let's see, November, October, that was a partial day. Tardiness, defiance, truancy. He's had a total of 51 unexcused tardies or absences for the school year last year total. He has ADHD and is supposed to be on medication, which to my knowledge, he is not taking. He has not been to the doctor since November of 2024. He missed his 6-month cleaning for the dentist and still has not been rescheduled.
All right. So you mentioned that you've asked him to come home several times. Have you taken any other actions for Taylor to get Taylor to come back to the house?
I've discussed it with John that I thought that it was in his best interest to be here. I did not seek, I guess, legal actions because I did not violation of the court orders or to get the police involved to bring him home because I don't want the same event happening and trying to talk to Taylor to find out things that were wrong, were unclear, and he obviously needed that space. So I was trying to give him some of that respect to let him sort things out. And till this day, nothing has been discussed about further detail or what needs to happen for next year so that he can graduate and have a successful high school years.
Has Taylor given any indication that he plans to come back to your house?
Not at this time, though.
What year is he in school?
This was his sophomore year. He still has his junior and senior year left.
So you mentioned that he's in summer school. Has he been promoted to a junior yet, or is that contingent on him completing the summer school?
That's contingent on him completing summer school.
Okay. And I guess passing the classes, right? Yeah.
Correct.
Okay. Pass the witness, Your Honor.
You may call your next witness.
The state would call Mr. Elliott. Mr. Elliott, how long has Taylor lived with you?
Taylor's been with me since September
All right.
of 24.
And under what circumstances did Taylor come to live with you?
One weekend during my visitation, Taylor was with us. Yes, I was over at a friend's house that I stayed with at that time, Joey Smalls. And during the visit, we did our weekend visitation and we took him back. A few hours later, the very next day, Taylor showed back up and we had a discussion, and he was told that, from what I was told by Taylor, that he was leaving over there because he was threatened by Kristen's boyfriend, Emmanuel Sukow. I did call Kristen about that, and for word to word, she told me exactly what Taylor told me also. Taylor was acting like I'm not going to use the word, and that if he didn't start acting straight, he was going to kick I'm not going to cuss. So the threats that happened several times, verbal abuse from him, the communication as far as talking about his brother, because Taylor does have a brother that's 23 and lives here also. Like I said, there was a lot of text message to Taylor stating that basically me and Colby are worthless, and Taylor was tired of it. I have not told him that he could not go back to his mom's. He does get punished over here for acting out. He does not get his phone taken away, because when Kristen did have custody, and if I called, she would tell me that he's grounded, that I couldn't talk to him. And I don't want that to ever happen. If he wants to talk to his mom, he is more than capable and able to. If he wants to go and see his mom, he is more than able. In the 9 months that he has been with me since September, I believe 9 months, he's been with Kristen. Thanksgiving, he was over there for a total of 5 hours. He did spend one weekend with her. Yes, they did go to one movie and 2 dinners. But in all this time, I have not asked her for any compensation as far as help. And when I have communicated with her, it's pretty much a finger blaming that I'm not doing what I'm supposed to do. And I have them in text here.
All right. Okay. So you're saying that Taylor wanted to come live with you due to his confrontations with his mom's boyfriend?
With Kristen and her boyfriend.
And you said it was verbal abuse. Is there any other reason that Taylor provided for wanting to come live with you?
He did tell me that he was pushed. He was tired of being worked. And
Being
yes,
what?
he did worked. Basically, he felt like he was a slave, that he had to go and cut her yard. He had to cut her boyfriend's yard. He had to do extra work for her boyfriend.
Is Taylor currently receiving care for his ADHD condition?
He has stopped himself on the medicine. We have talked to a doctor. I am working on getting back into therapy with Dr. Hirsch. And I already have a doctor's appointment to try to set up a doctor's appointment, or to try to get him basically with a new doctor, Dr. Casey Buck with the UTMB. That way we can get a primary care physician for him while he's here. As far as dentist appointment on a 6-month cleaning, I was never communicated to about that, or I would have had him there.
Is there a reason that Taylor needs new medical care providers instead of the ones he's previously seen?
He's wanting to go to a different doctor.
What's the holdup with starting the new doctor?
I've got the appointment going, and it's like I said, it's been what is it, the June 20, I think it was the 25th or 28th.
So you have a scheduled appointment.
Yes,
Okay. And it's just a matter of getting to that appointment.
yes, ma'am.
Is that doctor, is that a primary physician? Is it a therapist? Is it a doctor that will
The
prescribe medicine?
doctor, the Casey Buck is a regular doctor, and Dr. Hirsch is a family therapist. And I'm wanting him to go to somebody that is a good therapist. That and it's hard to get into it. It is extremely hard. But I'm trying to help Taylor by getting him mental help. Not that he's crazy or anything by that, but just somebody to talk to besides me or talking to his mom, and that has the knowledge to be able to help.
Has Taylor mentioned any plans to return to his mom's house?
No, I
Is he,
actually talked to him the other day, and he's wanting to stay here, which I wish he was here so he could actually talk to you.
and is that why you're not in agreement to pay or to keep paying Ms. Elliott current child support?
Yes.
All right.
Like I said, I'm covering all his medical expenses. I cover his medical, his dental, and his vision, buying his clothes, buying his food, keeping a roof over his head.
And are you requesting possession credits for the entire period of time you say that Taylor's lived with you?
Yes.
All right. Pass to witness, Your Honor?
Do you have any other witnesses?
No, Judge.
Okay. The state does not represent either of you. So I'm going to give you both a chance to speak if there's anything additional I need to hear. Ms. Elliott, is there anything additional you think I need to hear?
Yes, I would just like to address that he addressed Emmanuel Sukow as my boyfriend. I do not have a boyfriend. He is a good friend. And as far as him working, Taylor was doing yards and getting paid. It was a job. I even created the flyer. He was making close to $1,000 a month, doing extra jobs for Emmanuel. He went and other people, he went into high school with the trade center doing construction. That is what Emmanuel does. So he was teaching him how different things on the tools and how to use them and how to build things. And as far as working him, he wasn't out there doing anything that I was not out there doing. And the situation that he's referring to where Taylor and Emmanuel did get into it, that was on a Friday that I picked him up after he came back from his dad's. And he came back and he was already being disrespectful to me. And I had told him repeatedly to get it together. Let's just go do this because my fence fell down. And so we were putting it back up, trying to teach him, this is how you build it. This is how you level it. And, Taylor called me 3 weeks ago crying, asking me to pick him up because John's girlfriend, Wendy, and my older son were fighting. And he was scared. He called me. I was getting ready to walk out the door. He called me back and said, never mind. Colby and I are going to go take a ride. That's his brother. I said, okay. I talk to him on a weekly basis. He has been in the past. He has been around his brother. He has been around John when they've lost their tempers as well. And, there's been things that have been said that I think have been very detrimental. His older brother told him to go kill himself at one point, 2 or 3 times actually. So I realize there's a lot going on. My main interest right now is to make sure, because to my knowledge, John works out of town still. He still travels. So I understand there's other people there, but Taylor needs medication. I don't know why it's taken 9 months for him to go to find a new doctor or to get him on his medication. He needs someone to make sure he's there at school. He needs someone who's going to answer the phone when the school calls and follow up on disciplinary actions. Someone who's going to teach him the responsibilities to be a good man. He graduates in 2 years and he is so unprepared for the future.
Thank you. Mr. Elliott, is there anything additional you think I need to hear?
Yes, ma'am. As far as the argument, I don't know about the phone call. Yes, my girlfriend and my son did get into an argument. Was it a heated? No. Yes, I do travel, or I used to be an over the road truck driver. 98% of my jobs are now into Corpus Christi, right back, Sulphur, right back into Louisiana. Yes, I used to go over into other states, all over like Wyoming and stuff. Very seldom do I do that, and when I do, I have my mother come down and take care of what's going on. But Taylor has never not been picked up. He is always to school on time, either by myself, my son, or my mom, or my girlfriend. He's got a stable household. I've been doing woodworking for over pretty much all my life. My dad taught me, and that's what I've been doing with my son. He's got several projects out here on the patio that he has built, and I am trying to my damnedest to do everything I can for him. And as far as taking 9 months to get in a doctor's appointment, it hasn't. We just started this process a few weeks ago to get him into the doctor's appointment. I'm looking at a piece of paper at the dates to try to get him in. He was saying that he wants to go to a different doctor. I'm doing what my son is asking me to do. Does he get punished? Yes, he does. But I'm also going to treat him like an adult because he's 16, fixing to turn 17. I'm not going to go to the school and hold his hand and make sure that he gets to class because he's 2 minutes late. I can't do that. That's it. That's what a 17-year-old does for himself, 16-year-old does for himself. But even before Christmas, we all went to a school meeting. And yes, Taylor had over 40 days of missed school, and it wasn't missed. It was being tardied to a particular class, which was fifth period. And like I said, the school was supposed to be signing a contract and never did. I tried getting a hold of Miss Spencer over a dozen times. We finally got a hold of her when it was almost 2 weeks before school ended. But yes, Taylor is in summer school. And I think at the end of last week, he was 30% done with his projects to be able to be out of summer school. That's it.
And Ms. Laskowski, do you have anything further?
No, Judge.
What are
Just
you asking me to do with the arrears?
the state would ask the court to take a judgment on.
I have no testimony to do that.
All right.
Did I miss it?
No. They would ask for the court to modify Mr. Elliott's current child support and medical support based on the testimony that the child is currently residing with Mr. Elliott and award possession credits based on the same.
So you're asking for possession credits, but not a judgment. I'm going to order a temporary order in this case. I'm going to wait and defer on a judgment until evidence is presented next time on that. I am going to temporarily modify Mr. Elliott's child support to 0 beginning July 1st of 2025. I'm not modifying medical support. I have no testimony to do that. I'm ordering a parenting class for both parties to the 306, so you can attach the 306 list that they have online for that. And I'm going to reset to after the new school year begins and see where the child is at that time. I have grave concerns. A lot of my concerns are not actually before me. Concerned about the ADHD, concerned about school, and concerned about whether this child has a 504 or an IEP. But a lot of these things are out of my hands. But let's reset September 8th for final trial. And this will give you all a chance to work through some of the issues, hopefully get.
Starting with this child support dispute between Mr. Olzak and Ms. Purr. Here, the father claims he sees the kids nearly 50% of the time, pays their phone bills, and is with a pregnant wife and another child. But still, the mother here insists he doesn't deserve a break and still wants the full guideline support. Let's see how this plays out.
Mr. Olzak, if you can state your name again for the record, please.
Richard Maurice Olzak III.
Okay, thank you, sir. And counsel for Mr. Olzak. Can you state your name?
Good morning, Your Honor. My name is Beth Klein.
Thank you. And Ms. Parr, can you state your full name for the record, please?
Yes, ma'am. Mara Deanne Parr.
Thank you. And Mr. Olzak and Ms. Parr, if you can both please raise your right hands to be sworn in again. Do you each solemnly swear that any testimony you give today will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Yes.
Great, thank you. You can lower your hands.
Just going to say before we begin, we discussed possibly doing a temporary order. My client is currently has a wife that is pregnant and due in November. So instead of coming back, if the court would allow and everyone was still in agreement to proceed on a temporary order request.
Ms. Armstrong, do you have any opposition to that? It sounds like it might make sense if his wife is due in November.
Right. Another option, Judge, I was just thinking about is if the wife is due in November, I could do 2 different start dates. Mom is that way you don't have to come back. We don't have to do it. I can do 2 different start dates. So it would look like this. Child support for 2 children in this case would start July 1st, like we already agreed on the record, it would start July 1st, right? Then the amount would change starting December 1st, giving him credit for 2 kids on a different case, right? Adding in that other baby. Then I would do the step down for the minor child. That way they don't have to come back. We don't have to, he doesn't have to spend any more money with his counsel, and he gets the credit that he wants starting December 1st. And I think Ms. Parr is okay with that.
Yes.
Okay.
So-
And Ms. Klein, you're okay with that as well?
Yes, for now.
Okay. Yes, let's get some testimony and see where this goes. But yeah, those are both definitely options.
Okay. Thank you, Judge. May I begin?
You may begin.
Thank you. Ms. Parr,
Yes, ma'am.
as the judge reminded you last time, we had some agreements on the record, and you still remember what those partial agreements were. Is that right?
Yes, ma'am.
Now, one of those agreements we agreed to on the record is what Mr. Osak's income was based on the last 4 quarters average gross monthly income. Is that right?
Yes, ma'am.
And just to remind the court and everyone, that number was $9,549.36 monthly gross. Is that correct?
Yes, ma'am.
Okay. Okay. I just want to remind everyone of that number. Now let's get to what the child support calculated. Now, you understand that I had to calculate child support based on the guidelines, amount, giving him credit for taxes, union dues, that was on the record last time, as well as 1 child on another case with someone else. Do you recall that?
Yes, ma'am.
And that came to child support for these 2 children came to $1,615 per month based on the numbers that we remember from last time. Is that right?
Yes, ma'am.
And are you asking the court to start child support starting July 1st, 2025 per month based on these child support calculations?
Yes, ma'am.
Okay. And then child support would then step down to $11.69 per month when 1 child emancipates on this case. Is that right? I'm sorry, not $11.69. It would step down to $12.56, excuse me, per month. Is that right?
Yes, ma'am.
Now, you are willing to give dad some credit for cell phone bills that he pays for the 2 children subject of this suit. Is that right?
Yes, ma'am.
Does it sound right that he pays about $87 per month for the 2 children's phone bills?
That sounds reasonable. Yes, ma'am.
Okay. And so are you willing to deviate just slightly to give him credit for that $87 a month cell phone bill he's paying for the 2 children?
Yes, ma'am.
Okay. So if my math is correct, instead of $16.15, which is what guideline says, that will lower it to $15.28, that $87 difference being for the cell phones. Is that right?
Yes, ma'am.
Okay. And so then you would want $15.28 to start July 1st, giving him credit for those cell phones. Is that right?
Yes, ma'am.
And then starting December 1st, his child support, his guideline amount would have been $14.80 per month. 2 children in this case, 2 children somewhere else. Is that right?
Yes, ma'am.
If we subtract that $87 again for the cell phone, then that $14.80 then becomes, my math is right, becomes $1,393. Is that correct? $1,393. Is that correct? That sound about right, Mr. Parr?
Yes, ma'am.
And you'll be willing, even though the child's not born yet, you'll be willing to go ahead and do a second start date starting December 1st for that amount, and then do the requisite step downs as this 1 child in this case emancipates. Is that correct?
Yes, ma'am.
Okay. I pass the witness.
Okay, Ms. Klein, do you have questions for Ms. Parr?
Just quickly, Your Honor. Ms. Parr, you and Mr. Olsak were divorced on June 9th, 2021, and did an agreed final decree of divorce, correct?
Yes, ma'am.
I ask the court to take judicial notice of the agreed final decree of divorce.
I take judicial notice of their agreed final decree. It did contain it's called a super expanded possession order and set child support at $800 with a step down to $600. Take judicial notice of that decree.
Thank you. And Ms. Parr, under the super expanded possession order, on the first, third, and fifth weekends, Mr. Olsack would get the kids on Thursday prior to those weekends and ending at the time school resumes on the following Monday, right?
Yes.
And then on the non-weekends, he would get the kids after school on Wednesdays and return to school Friday morning, correct?
Yes.
And then in the summers, you guys would go week to week.
Yes.
And the holidays would be per the standard where you would get your spring break, he would get his, and you would each get your own Thanksgiving, and then you kind of split the Christmas, right?
Yes, ma'am.
Do you agree with me that Mr. Olsack has consistently and routinely exercised possession under the final divorce decree?
Yes.
Are you aware that Mr. Olsack has pled for a deviation on child support?
Yes. Go, darling. Go play.
How many other children besides, well, how old is Richard? The fourth.
He's 15. He turned 16 in October.
And how old is Fallon?
She just turned 14.
Do you have any other children besides those two?
I do.
And what are their names and ages?
Objection relevance, Judge, to current child support on this case for dad?
It's an additional factor to consider if the court were to deviate from guideline child support.
I'm not aware if she could quote what family code that is that takes into consideration mom's other children when dad wasn't paying child support.
We're looking at Texas Family Code 154-123.
Number 7 does say whether either party has the managing conservatorship or actual physical custody of another child. So I'm going to overrule the objection and you may answer.
How many other children do you have?
I have 2.
Okay, and what are their names and ages?
Glenda Lola Mae Parr. She's 3. And Cameron Lee Parr Jr. is 5 months old.
And do both of those children reside with you?
Yes.
And are you working?
No.
I pass this witness.
Okay. Ms. Armstrong, you may call your next witness.
I have no further witnesses, Judge.
Okay. Ms. Klein, you may call your witnesses.
Thank you, Your Honor. Cross petitioner calls Richard Olsack.
Yes, ma'am.
State your name for the record.
Richard Maurice Olzak III.
And you are the father of Richard IV and Fallon.
Correct.
And how many other children, as we sit here today, do you have as we sit here today?
1.
And what's the name and age of that child?
He is 1.5 years old, and that's Braden Alexander Olzak.
And you're currently married?
I am.
And your wife is expecting another child?
Correct.
And when is that child expected to be born?
November 4th
Of 2025?
of 2025.
Is your current wife working?
No, ma'am.
Why is she not?
Because she's pregnant, it's gotten a bit too rough for her.
You have asked the court to deviate from guideline child support, correct?
Yes, ma'am.
And if this court orders the child support at approximately $1,500 per month, would that cause you financial strain?
Absolutely.
Do I have permission to share?
Yes, ma'am.
I'm going to object for sharing as nothing has been admitted into evidence. So I don't want to see the court
would-
to see it yet.
Okay.
And also, I was never given any exhibits as well. So that's my other option.
Well, the 3 exhibits that we have that I'd like to move to admit would be his pay stubs, his 2024 1040, and a financial information statement.
And I would object to all of those, Judge, as his income is not in dispute. His income of $9,549.36 monthly gross was agreed to and testified by the child support officer last time and stipulated by the parties. So I'd object to all those 3 exhibits as being not relevant to what current child support should be.
The financial information statement is relevant for the deviation of guideline child support.
Yeah, I'm going to grant the objection with regard to the pay stub and the tax return, was it? Because that was, but I agree the financial information statement has other information. So I'm denying the objection with regard to the financial information statement.
Can Ms. send that to me? Because I have not received it.
Yes, can you share that, please?
So that's my other
Absolutely.
objection. It's not timely presented, does not give me time to prepare for it.
in light of this is 4D court, I'm overruling that objection, but please send it to her. And if we need to take a break, we will. We've done lots of hearings in 4D court where we take long pauses for sometimes up to an hour. So we will do what we need to do to get this resolved today.
Thank you. Permission to share, Your Honor?
Actually, can you email it to her? Because I can't see it yet until it's admitted.
Sure. I don't, Your Honor, I apologize. I was on vacation last week and it was my first day back. I don't know if I have your email.
I'll give it to
Ms.
you.
Armstrong.
It's CSD. It's our legal service email address for Lamarck, which is CSD dash
Oh, that
legal
one.
dash 1002. Yes, that one. That's where everything should be sent to.
Okay.
Thank you.
Apologize.
And Ms. Parr, have you received a copy of this exhibit?
No, ma'am.
If you could email it to Ms. Parr, she is pro se.
Ms. Parr, may I get your email, please?
Yes, ma'am. It's SY1 P as in Paul HID SCRI B as in boy B 1ES at gmail.com.
Do you care if I confirm that real quick, Ms. Parr?
No, go ahead.
You'll want to do that in the chat, maybe instead of
On the
repeating it publicly again.
Oh, yeah.
Okay, thank you.
Sorry.
That's okay.
Here, I'll just email what I think I emailed. Or what I heard. I apologize. Did you both receive it?
I'm checking right now.
I did receive it, Ms. Klein. Thank you.
Yes, ma'am.
Ms. Parr, did you receive it?
Yes, ma'am.
I'd like to go ahead and, may I proceed, Your Honor?
Has everyone had a chance to look at it?
I've looked at it. Yes, Judge. Thank you.
Okay, yeah, we may continue.
There's a few errors on it that I will just have him correct through testimony regarding the income based on what was previously stipulated, but the expenses should be accurate. It looks like the income was created based on using some pay stubs. So that's going to be different than a totality that was previously stipulated. Counter petitioner moves to admit CP2.
Is there any objection to admitting
Yeah.
CP2?
Yes, Judge, I object to page 1 of the exhibit. I have no objections to page 2 of the exhibit. Page 1 states what his income is, net income, which again is my same objection. The income is already being agreed to and stipulated to. So I object to page 1 for those facts, but have no objection to expenses, which is only listed on page 2. So I'm okay with page 2 coming in.
The only thing with Your Honor is on page 1, it breaks down the deductions, retirement, the other expenses that would otherwise be taken into consideration and deviation that's not always taken into consideration in a when you do the standard guideline support. So I'm not moving to admit it to alter what has been stipulated as to income, but to alter or to offer the expenses and the other things that my client has coming out of his paycheck as a result to show why we're asking for a deviation.
Ms. Parr, do you have any legal objections?
The same as Ms. Armstrong.
Was it CP2 or CP1? I'm sorry.
The first page.
No, Ms. Klein was the name of the objection.
I see.
CP2, what's it called? CP2. Okay. I'm admitting CP2 into evidence.
Permission to share, Your Honor?
Ms. Harper, can you give her co-host, please, so she can share? You should be able to share.
Mr. Olsack, can you see what's on my screen?
I can.
Okay, I'm going to scroll down. We're going to go past the income. So if we use the state's calculation for, well, real quick, what do you do for work?
I'm a UPS driver.
Okay. And so there are some months that you'll make good amounts of money and some months that you'll make not as much overtime, right?
Yes, ma'am. All depends on the route those days or that week and the
Your Honor,
amount
I'm
of
not
overtime
objecting to any
work.
line of question that deals with his income and what he makes, as that was stipulated to at the last hearing.
Overruled.
So if you look at we're going to go real quick here on your total resources, that amount is incorrect. If we're going to use we're going to use total resources of 9,500 just for purposes of this hearing. Okay.
Okay.
Okay. These deductions here, you have you have retirement that comes out of your paycheck every month.
Yes, ma'am.
How are you paid? Well, are you paid every other week? Are you paid?
Oh, weekly. I'm sorry.
And then the child support here that comes out of your paycheck, that is your current amount of child support, correct?
Correct.
Then if we go down to your expenses, you're paying for the house, utilities, food, car payments. Are any of those car payments for the children?
No, ma'am.
And then if we scroll down a little bit further, your grand total monthly. I apologize, Your Honor. This was done without me seeing it. Let me just ask you this way. If this court orders the child support, right here, if we look down here, you're negative based on the current income and based on your current expenses. So if we were to add the additional 4,000 that's missing from the income calculation, you would basically break even per month based on the current child support. Would that be accurate?
I don't understand what do you
Okay.
mean?
Your current child support right now is approximately $800.
Correct.
Based on the income of 9,500, even though that was stipulated, you knew I disagreed with that amount, right? Based on, if you use the 9,500, taking into consideration your other expenses and your other deductions, you're basically breaking even each month with the current child support obligation per the divorce decree.
Oh, yes, ma'am. Currently, I'm barely breaking even some months, and it is what it is, but it's
If this court raises your child support to be close to $1,500, are you able to financially afford that?
no, ma'am.
Are you asking this court to deviate from guideline child support and to set it at $1,000?
Yes, ma'am.
And does that take into consideration that you have the children close to 50% of the time, and also the offset for the or for the cell phone allowance?
Correct. Which I didn't know when to speak up. I don't know where
Objection, non-responsive after correct.
Sustained. Sir, just listen to the questions your attorney asks. She can ask more. She knows how to ask more if she needs to.
Yes, ma'am.
Thank you.
What other reasons are you, the code allows for any other reason consistent in the best interest of the children. What other reasons are you asking the court to deviate from guideline child support?
I don't understand. I mean, I would have to, I don't have enough time in my day to take on more hours. I don't know where I would get more funds to pay more money. We don't live lavishly. I make sure the kids have everything that they need, but bills being the
Objection,
way that they are,
non-responsive to her question.
I thought that's
Sustained.
what they were asking. Sorry.
That's okay. If this court sets this child support at approximately $1,500 per month, would you have to lose time with your children in order to be able to financially afford that?
Objection calls for speculation.
Well, would you have to get a second job?
Objection calls for speculation.
I don't think it's speculation if he knows his finances, Your Honor.
Am I supposed to answer?
Overruled.
Yes, I would absolutely have to get a second job. My time being stretched as thin as it is, it would definitely take away from the rest of my time with the family. I would not be able to see them.
Objection, non-responsive at this point.
Sustained.
And when you heard Ms. Parr state that you consistently see your children under the super expanded possession order. What types of things do you and your children do together?
We play video games. We like to go out to my mom's house a lot. If we're not going to my mom's,
Objection, relevance.
I think it goes into a deviation requirement as to best interest as well as to possession. And if this court alters the child support to be the 1,500, he would have to get a second job and lose time with his children. Ultimately, that's a best interest factor.
That's not in evidence. So I will hold my objection as to relevance as to what they do when he's with his children.
Sustained.
I'm going to pass the witness.
Ms. Armstrong, do you have any questions for Mr. Olzak?
Yes, please, Your Honor. If I could share my screen with the CP exhibit number 2.
Is that the one that's the one admitted into evidence?
Yes, ma'am.
You may do so.
Thank you. And let me know when you can see my screen, Mr. Olzak. You able to see the financial information statement?
I am.
Okay. So I'm going to go down here where it says net income. So this is the amount that your attorney was questioning about. So this $2,274.59. That's your net income based on that.
Can you zoom in a little? Because I know I can't see that number. I doubt anyone else can.
Yes, Judge.
Thank you.
Absolutely.
Thank you.
That's better for me too. So this net income down here, now this is your financial information statement. You recognize it to be the same as the one entered into evidence, correct?
Yes, ma'am.
Now, this says that you would have a net income of $2,274.59. Is that what this says right here, net income?
Yes, ma'am.
Okay, now this again was based on a wrong payment that you get, correct? This was only based on income of, if I scroll back up, it was only based off of income of $5,100. Is that right? According to
Correct.
this.
But
Okay, thank you. So we know that if your net income is 2,274 based on that number, and we know that your monthly gross income is actually about $4,000, 4,400 per month more than the number that this was based on, that this number would increase as well. Isn't that correct?
I'm not understanding. We're getting into
Okay,
jargon now.
no worries. So this net income says 2,274. You agree with that?
Yes.
You also agree that net income was calculated based on an income of 5,100. Do you agree with that?
Yes, it's calculated on income of 5,100.
You also agree that your income is actually $9,549 monthly gross that we stipulated to last week. You agree with that?
Well, that depends on which payment or what route I'm on and what month, honestly.
Object non-responsive to my question. Let me ask again. My question was, last week we stipulated that your monthly gross average income was $9,449. Isn't that correct, Mr. Olzak?
Yes, ma'am.
So if I add that extra $4,400 monthly gross, increasing your gross also mathematically increases your net. This number here, don't you agree with that math?
Yes.
Okay. Isn't it true that your visitation is not more than 50%? It's not even 50% when you add up the days that you actually have the children based on the close app you and Ms. Parr use to calculate percentage. Isn't that correct?
I'm sorry, what was that question? I didn't follow it.
No worries, Judge. Do you also agree that y'all have a program called App Close that y'all use to calculate percentage of visitation time? Do you agree with that?
Yes, ma'am.
Do you also agree that for 2024, you did not have the children 50%? Do you agree with that based on the App Close that y'all use?
Yes, ma'am.
Okay. And you may not know this, but do you also understand that based on the Texas Family Code, you are given visitation and order to pay guideline amount according to what the legislature has designed it to be?
Objection calls for legal conclusion.
I said, if
Sustained.
you may know. Okay. Are you also aware that Ms. Parr pays for band for the children?
No,
Are your children in band?
they are.
Okay. Are you aware that it's not free?
I am aware.
Okay. Are you aware that someone has to pay for it?
Correct.
Are you aware that she has a $3,000 payment coming up?
No.
Okay. Have you ever? Okay. I pass the witness, Judge.
Ms. Parr, do you have any questions that you would like to ask Mr. Olzak?
No, ma'am.
Thank you. Ms. Klein, do you have any further questions for Mr. Olzak?
Just a few.
You may proceed.
The instrument, regarding the band, the instrument that Richard IV has, who bought that instrument?
Oh, me. I'm sorry.
That's okay. And who pays for the repairs of that instrument?
I do.
And the band instrument that Fallon, is she also in the band?
She is.
Okay. And how did she get her instrument?
That I can't recall. And I want to believe that it was my brother, but I can't recall. So
And you and Miss Parr communicate using App Close?
we generally communicate via Messenger and Facebook. We've been amicable, I guess.
Prior to the start of this hearing, did you have any knowledge or anything from Miss Parr indicating that there's a $3,000 payment coming up for band?
No.
Even though we stipulated to your your income for the 12 months being the 9,500, each month you don't make 9,500. Is that accurate?
As it was stipulated to and not relevant for this hearing on current child support.
Your Honor, ask the witness.
Does anyone have any further questions for Mr. Olzak?
No questions from Ms. Olsek. If I could recall Ms. Parr.
You may do so.
Thank you. Ms. Parr, I'm sorry. I muted you earlier because of the baby. Do you mind unmuting yourself? Sorry about that. Ms. Parr, just a few more questions, okay?
Yes,
Based
ma'am.
on testimony. Now, your two children are in the band, is that right?
Yes, ma'am.
And is band free?
No, ma'am.
And who's been paying for their band all these years?
I-
Has Mr. Olsek ever paid half of those extracurricular activities for a band?
No, ma'am.
And you do agree that he paid, do you agree that he paid for Richard the Fourth's instruments a while back?
Yes, ma'am.
And did you pay him half of that instrument?
No, ma'am.
And did he pay you half of the band costs for the two children?
No, ma'am.
So it's like a wash. Would you agree?
Yes, ma'am.
Okay.
The fees are pretty expensive.
What are those fees for band?
For our son for last year, I'm sorry, I have it on my paper here.
Mhm.
It totaled $788.
And that was just for Richard the Fourth's band
Yes,
fee?
that includes like their uniform. They need like special shoes, things of that nature, and it's a list that the school provides.
And did
our
Mr.
dau-
pay
I'm
you
sorry.
half of those fees?
No, ma'am.
Has he ever paid you half of any of those fees for either Richard the Fourth or for your daughter's band?
No, ma'am. And then for our daughter for this year, hers, because she's moving into high school, so that's when these fees start. Hers is $406.25. And
And
then,
that's coming up for the fall when she starts high school. Is that what you just said?
yes, ma'am, and that's been paid as well.
And did Mr. Olsak pay you half of that?
No, ma'am.
And if you were not to get the guideline child support minus the cell phone bill, would that cause a financial hardship for you and the two children you have with Mr. Olsak?
Yes, ma'am, it's already a struggle. We all know how expensive everything has been right now, especially food. And two teenagers eat a lot.
And y'all have the app close program that I spoke to Mr. Olsak about. Is that right?
Yes, ma'am.
And in that app, are you able to count the percentage that each parent has with the children?
Yes, ma'am. It shows it on a calendar. And so I counted the physical nights because I know it goes by nights for each of us for 2023 and 2024.
Let's talk about 2024, so that's most recent. In 2024, did Mr. Olsek have the children 50% or more?
He had them 46% and I had them 54%.
Okay, so he did not, to answer my question is no, he did not have them
No.
50%. And based on that and the hardship and all the band, you're asking for guideline amount for those reasons, is that right?
Yes, ma'am.
And you're still willing to give $87 a month credit for the cell phone bill?
Absolutely.
And you're also willing to start child support of $13.93 per month starting December 1st, which will give him credit for two children that he has with someone else. Even though that child has not been born, you're willing to start that December 1st. Is that right?
Yes, ma'am.
Okay, I pass the witness, Judge.
Ms. Klein, do you have any questions for Ms. Parr?
Just quickly, Your Honor.
Okay.
Did you happen to tell Mr. Olsak about the expenses for band that you just testified to?
I did not. And the reason for that has been
Objection, non-responsive after I did not.
Sustained.
Okay. How long have you not been working?
Since December or November, I
Okay.
apologize, of 2024.
And so are you capable of working or are you just choosing not to work?
Objection, not relevant, Judge. So what he's gonna pay her for child support?
Overruled.
Are you capable of working or are you choosing not to work?
At the moment, I'm not capable of working. I breastfeed my infant and I have never been able to pump with any of my 4 children. It just doesn't work for me.
Pass the witness.
Ms. Armstrong, do you have any further questions?
Oh, no, Judge, thank you.
Does anyone have any further witnesses? I'm going to allow you all to make brief closing arguments. I guess we'll start with Ms. Armstrong since it's your pleading.
Thank you, Judge. We asked the court to approve the stipulations made last week, and the only remaining issue was current child support for today, Judge. We heard testimony from both parties. We've heard testimony of what guideline child support should be, which is $16.15 per month for 2 children on this case, 1 child with someone else. That's based on Texas Family Code. Mr. Olsak has failed to prove that he has the children 50% or more to deviate in that manner. The Texas legislators have set it up where a parent can have an expanded SPO and still pay guideline amounts. We also heard testimony that the children are in band, which is extracurricular activities, both children are, and that Mr. Olsak, while he did pay for 1 instrument a few years ago, there have been several other band fees that Ms. Parr has been paying on her own, which not only would it be a wash, Your Honor, she would probably owe her money at this point, if she were to take that up, but she's doing it by herself through testimony that we've heard, okay? Based on that, she's also willing to give credit to a child that's not even born yet, starting December 1st of that, this lower her child support to $13.93 at that time. Based on all these factors, Your Honor, we ask that child support be deviated slightly to $15.28 per month to give dad credit for that 87-month cell phone he has for the two children. And then, excuse me, and then for child support to then go down to $13.93 per month, starting December 1st, 2025, to give him credit for the unborn child that will be born at that time. And then asking for child support with one child on this case, emancipate, to go down again to $11.48 minus whatever the $87 would be, which would make it the $13.93, I believe. At that time, Your Honor. Thank you.
Thank you. Ms. Klein?
Thank you, Your Honor. We've asked the court to deviate from guideline child support based on Chapter 154, 123, additional factors for the court to consider. The big is the amount of time of possession and access to the child. He has close to near 50% of possession with the children. To change the child support to increase to $1,500 is going to be a financial strain on both on him. It's not going to be able to make ends meet. Both mom and dad in this case are very in similar situations. Mom says she can't work with two young children because of not being able to breastfeed. My client's wife can't work because there's a young child and she's currently pregnant, not able to work while her difficult pregnancy. So in this situation, the state guideline child support is simply not in the best interest of the children. And we ask the court to deviate from guideline child support to be $1,000 per month. Thank you.
Ms. Parr, is there anything additional you would like to say in summary?
Only that it's not a true 50-50 split as has been claimed with time between me and Mr. Olzak, and that I believe guideline support is in the best interest of our children, considering I do believe that he makes enough to manage that as far as his income, and considering all the fees and stuff that are required of the children that I do pay because of him having paid for the trumpet. Other than that, there's not really anything else.
The time estimate is only one issue remaining for the court. I'll state the agreed issue. So I would say on the one issue, maybe 10 minutes.
Okay.
My estimate. If I may put the agreement on the record first, Judge.
You may do so. Thank you.
The parties have agreed to the following. As the judge court stated, this is a motion to modify and confirm arrears that was filed with this court. The parties have agreed to court. They understand that court costs, if billed by Galveston County, would be against Mr. Olzak. I'll put as billed due June 2nd, 2026. Child support arrears, they agreed to a child support arrears judgment against Mr. Olzak according to our pay record of $7,035.39. That is as of May 31st, 2025. He's agreed to pay that child support arrears judgment back by paying $35 per month. That $35 payment will begin July 1st, 2025. As when one child emancipates, if there's a balance remaining at that time, he will pay $398 per month towards that balance. When both children emancipate, if there's still a balance remaining at that time, then he'll pay $1,670 per month at that time. Parties agree to allow Mr. Olzak to continue to provide private medical and dental insurance for the two children subject of this case through his employer. He pays $0 for medical for both kids and $0 per month for dental. It's no cost to him, which is great. I wish I had that. And so,
First I've heard.
yes, they will pay 50% each of any unreimbursed medical expenses, of course. And they do agree that dad has union dues of $240.50 per month. They also agree that dad has one other minor child with someone else that resides in his household. And so the child support calculation would be based on 22.5% for guideline calculation amount. 2 in this case, 1 outside this case. They also agree that for the last 4 quarters, that his average monthly gross income comes to $9,549.36. And that's monthly gross before any deductions or anything are taken out. Okay. The only thing remaining for the court to decide is what current child support will be. and then what the step down would be when one of the children on this case emancipates. I will like to, and that's all I have for the agreements. If I may call Ms. Ozak first on the agreed terms.
You may.
Thank you. Mr. Ozak, were you able to hear the partial agreements as I stated them to the court just now?
I was.
And was that in fact the partial agreements you made here today?
I don't understand the question. Is that what we talked about privately, you mean?
That's correct. Were those your partial agreements? What child support arrears would be, that you're gonna pay $35 a month on those, what your
Yes,
income
ma'am.
is, that you have one child with someone else, all those things I just stated to the court.
Yes, ma'am.
Okay, and do you agree with me that the only thing the judge needs to decide is what current child support would be and what the step down child support will be starting July 1st, 2025 for current support?
Yes, ma'am.
Okay, I passed this witness on the agreed terms.
Ms. Ellis, do you have any questions for Mr. Olzak on those terms?
No, Your Honor.
Okay, thank you. You may continue.
I'll call Ms. Parr on the agreed terms. Ms. Parr, were you also able to hear the partial agreements I stated to the court just now?
Yes, ma'am.
And were those in fact the agreements, partial agreements you made with Mr. OAG today,
Yes, ma'am.
including the child support arrears that he owes you?
Yes, ma'am.
And you're okay with the payout? I know it's kind of low, but you're okay with the $35 in payout starting July 1st, 2025, is that right?
Yes, ma'am.
And do you also agree with me that the only issue remaining for the court to decide in this matter is what current child support would be, and then what the step down amount will be when one of your children emancipates? Is that right?
Yes, ma'am.
Okay. If I could go ahead and ask her the disagree questions.
Yeah, and then Ellis, I'll give you a chance when she's done with all of them to question hers. Okay.
Your Honor, I was going to ask for an oral
Okay.
motion for continuance on that one issue, since I'm not the actual attorney of record for Mr. Olsak. The attorney of record does have a vacation letter on file for this week. It was timely filed.
Your Honor, we were not made aware of this issue. She
I did
represented to me
mention
that
it
she was.
in,
Excuse
did
me, Ms.
mention it in
Ellis.
the-
Excuse me, Ms. Ellis. One at a time. If you want to finish, you may go ahead. But we have a record, so we have to go one at a time.
Yeah, so Ms. Ellis, why don't you finish and then I'll let Ms.
Yeah.
Armstrong respond.
I'll finish.
Okay, Ms. Armstrong?
Judge, we were not made aware of this when trial was set this morning. When we got there, we were told that we were waiting for Ms. Ellis to arrive. We waited almost an hour for Ms. Ellis to arrive, which was fine. She was in another court. But had I known that she was not going to take ownership of this case, we would have reset it an hour, 2 hours, 3 hours ago. I would have not have gone through negotiation. I would have not have wasted time going through negotiation. And we already to begin this trial. I feel like we've begun this trial. It's on the record. We've started. And I think her motion for continuance is untimely, as we have already begun trial. And we've gone through 3 hours of negotiations. So I'm opposed to a reset at this juncture.
And I did come from the other court. I was under the impression that this was a negotiation conference that I was stepping in for Ms. Klein on. And then I found out it was a trial, and she does have a vacation letter on file. So if it was not timely, that is on me, but I am not his retained counsel for this matter.
Judge, she works for Ms. Klein's office. She's an associate in that office. As we know, as attorneys, you can represent a client if you're an associate of that case. I would not have wasted 3 hours of negotiation and began this trial just now if Ms. Ellis did not have the authority to do so, which I feel that she does, but that was not made clear.
Okay, yeah, I'm not thrilled with this. That being said, they're lawyers, they know how to de novo well, and so I don't want to waste even more time in a trial that's going to get de novoed so you can have the same issues heard. All that being said, after all the agreements are made, I'm not what is the disagreement over child support to gross union dues, child support amounts, and a percentage?
Your Honor, there should be an offset, and there are some other discrepancies. I mean, the possession schedule is almost 50-50, and not considering the FIS and some of the other factors, he's barely treading water with what he's paying now. So it's just an issue.
Your Honor, as we know, the standard possession order is designed to be almost 50-50. Yet
It's not the standard
code still allows child support to be set based on guideline amount, which is what was calculated in this case.
Okay.
So.
Okay, knowing all this, can we just reset this to June 9th? Next Monday, will she be back June 9th?
She has a trial the next day, but she should be here the 9th.
Okay. I'm going to approve the agreements before I reset this, so we're not going to rehash all this. Like, this is a done deal with those issues, and then the remaining issue will be the only one heard that day. Ms. Parr, are you available that day?
Yes, ma'am.
And Judge, can we state as well on the record, and I'm just asking, can we make sure we go forward with orders that day, regardless of what attorney appears to represent Mr. Olzak? So we
Yes,
won't
I
have,
am resetting trial. So no one can show up and ask for a referral to district or a reset because they need more time. Trial has begun, and I'm pausing trial as a courtesy to allow the retained attorney. I've been an associate, I understand. But trial has technically begun. We began this case in addition to the negotiations. Everyone's on the record, everyone's sworn in. We began. So we are proceeding on June 9th, 2025 at 8:30 a.m., the same Zoom information. And I am finding, based on what's begun, that the parties have an agreement on all the issues that were read into the record by Ms. Armstrong. That includes the court costs for Galveston County. Everyone's agreeing that Mr. Olzak will pay them on or before June 2nd, 2026. I'm ordering an arrears judgment against Mr. Olzak in the amount of $7,035.39 as of May 31st, 2025. And based on everyone's agreement, I'm ordering that he pay that back at a rate of $35 each month beginning July 1st, 2025, with a step up to $398 when one child emancipates, and then a step up to $1,670 when both children emancipate. I'm ordering Mr. Olzak, based on the agreement, to provide medical and dental insurance through his job, which is no money. I'm ordering the parties will each be 50% responsible for unreimbursed medical expenses. I'm finding that Mr. Olzak pays union dues of $240.50 per month. I'm finding he has one other minor child outside of this case that he's responsible for. So child support per guidelines would be 22.5%. And I'm finding that the parties agree his last 4 quarters monthly average, or his monthly gross based on the quarters, are $9,549.36 per month. And I'm finding that the issue remaining that will be heard commencing on June 9th, 2025 at 8:30 a.m. will be current child support and the step down. So we are just pausing this hearing. It has already commenced.
thank you, Judge.
Thank you.
I'll email everyone a copy of that reset date, but it's on the record, and I'll see you on June 9th. You're all free to go if the judge is done.
Yeah, you're free to go. Unless anyone has any other questions, everyone's free to go.
No, ma'am.
Thank you all for coming in, and we'll see you next Monday.